minutes away.
13 minutes away?
So I guess this will be here around 10.
10. What was his deal? He thought it was at 10 or he's stuck?
No, there was an accident.
Had he already left you a message?
No.
Okay. So, okay. We will have less time to talk about it. Just so you know, Mr. Deering, I was going to have Mr. Rucker go first. I'm pretty familiar with the case because this is round 2, different plaintiff, but same bus. I've watched that video a bunch of times.
Bless you.
We have a MARTA trial starting tomorrow.
Oh, okay.
One where MARTA has already admitted liability. Bus was traveling eastbound on Cleveland Avenue and a car stopped in front of the bus somewhat abruptly, but not like the facts in this case.
Right.
And the driver was going way too fast. And so he said, I'm going to hit this car. I'm going to move over into the other lane of traffic. And it was a minivan. So I don't know what the driver could see. You can't see it from the video. So watching the video, you don't notice there's a Nissan Sentra coming in its correct lane of travel.
Right.
So head-on collision.
Okay.
So
Wow.
MARTA needs to eat that one. So it's a damages trial.
Right.
But it's big numbers. So
Right.
we'll see what happens.
Right. I mean, you know, I didn't want to bore you with this, but you know, you seem to be more than familiar from the order that you entered in the last case, and you know.
So I'll hear from Mr. Rucker, but one, he's going to have truncated time because he's running late and we've got a 10:30.
Sure.
But two, just because of my familiarity, it'll be a lot more helpful to hear why he thinks this ought to get to a jury. So you'll get a chance to respond. I didn't want you to be, wait a minute, it's my motion.
Sure. No, that's fine. Thank you, Judge. Appreciate that.
Do you have a sense of the 11 o'clock's duration? The 10:30 will be short and we may start it a little late.
I do not.
Okay.
I think I just kind of set it for that.
Yeah.
Surgery petitions, I feel like we're in an hour, but
Well, and it may be that there's only one of the 3 parties showing up, which will make it go even faster.
that's likely.
Okay.
And it's confined to that hour. So
Okay.
it's not like we're gonna be going through exhibits.
Yeah.
It's going to be a bridge to the left or across. And 18.
Hello.
Good morning, Judge. How are you?
I'm well. How are you?
I'm great.
We're waiting on an attorney, so it's going to be quiet here for another 10 minutes or so.
Good. I'm waiting on the board.
Yeah.
Judge, this is the first time I think it's the first time I've actually appeared before you. You were involved in another case though that I had some tangential involvement. It was involving tax bond validation objections by
This is the Gulch case?
one of them, right? And it was involving what's the guy that files the objections all of the time?
Woodham?
Yeah. How can I forget his name? Yeah, I had several of those. I've had a couple involving him.
What was your connection to the Gulch one?
I was involved in, I was representing the city of Atlanta, the city of Atlanta's interest. And I actually was doing work for the Development Authority also. And, you know, those cases started coming up and I got involved. I probably had 3 or 4 cases with Mr. Woodham.
He's still out there.
I don't know where, but
He's got his own firm, and he pops up in cases. He was behind the scenes on this one. The gentleman who brought the cases was a young lawyer, real smart, very promising, but was sort of a marionette in that one.
Right. African American, young African.
Yeah. I was very
remember.
impressed with
Yeah.
him. I just felt a little bad because he was getting pounded on by these very seasoned attorneys who dealt with these things before and had dealt with Woodham before.
Right.
And so they sort of knew what was coming before he'd go for a jab. They'd know, here it comes. And, but he's got a promising career. He just needs to not necessarily
associate himself with John.
Exactly.
It's interesting that he had a case where he had objected to a bond validation, and this case had gone on quite a while, and it was with former Judge Johnson.
Mm-hmm.
And there was some allegation that he had basically tried to extort money out of the developer to drop the.
Wait, Woodham or, oh yeah, that agreed. That went all the way up to there are some who marvel that
I'm one of those.
He has a law license.
Yeah, I'm really, based on what I saw and what I read, I'm surprised. I mean, he's a smart as hell guy, but I just
in that niche.
Yeah, he is. He's something else. We actually had to take a deposition. I had to take his deposition once, and he was so different that I asked to take the deposition here in the jury room with the judge. So anytime there was an objection, we go and knock on the door.
I've had a couple of those, not with him, but in cases where, like, you know what, you can do it in the jury room.
Right.
So I can just walk across the hall and knock your heads together and say, come on.
Right. I felt so bad. It was an older judge who just retired a couple of years ago. And, I'd ask him a question and he'd say, I'm not going to answer that. Okay. Oh my God, this is not why I went to law school and deal with this guy. Man, you have a pen I could borrow? Because I walked out without my watch.
We go grab you one.
Thank you, I appreciate it. Thank you very much. Thank you so much. I appreciate it.
Of course.
Walked out.
So Lucky Bucks is substantial compliance legally sufficient.
Yeah.
That will not take an hour and a half.
Works for our child tomorrow to tell me if there's some sort of. Sure, right,
Hmm.
but.
Yeah, we have
I
lots of
think
money.
so, but
Is MARTA self-insured or does MARTA have some big oil insurance company?
Self-insured.
Okay, there you go.
on the pretrial order, they have the fee listed. So I'm a little confused about,
Oh,
maybe that's. Or something.
yeah, no, that's a good question to ask though.
Sure. And you want 36 jurors, right?
Yep.
Not 48.
No. Yeah, there are some insurance companies. So there's some of them that are these litigation funding companies. And then
Some smaller insurance.
Lexington Insurance, Aegis Insurance, Markle Insurance. I don't know what all, there's so many.
Yeah, that's what I'm nervous about. But I guess.
And-
it's common, so.
Yeah. Yeah, why don't you ask them how they want that part done? The earlier ones, Silver Dollar Financial and things like that, that we can do
Here.
with the jurors.
Yeah.
It may be that the lawyers don't care that we're also asking about these obscure ones, but the I word is in most of them, insurance.
Yeah.
But I don't know that it's really jury services job to do so many, and it's not Geico, but I guess if we may have to, well.
That's the only thing they pre-qualify for over there.
Are those few Geico, Allstate?
Yeah.
Okay.
The big ones.
Okay.
Progressive.
I don't know why we would need to do it for these. They're not going to, if they don't come up, it doesn't, let's say that juror 19 has a policy with Markle Insurance. If that's not coming up, I don't understand why that matters.
Yeah.
Because they've agreed through the motions eliminate, no discussion of insurance.
Oh,
Or,
no, never.
yeah.
I asked them, so let's see. I doubt they'll have strong calls.
There we go. We are unmuted. So we are here on the matter of Jasmine Pullen versus MARTA and Ms. Vachon. I'm not quite sure how we say her last name, who's the driver of the bus. This is a motion for summary judgment that Mr. Deering has filed on behalf of his clients, the defendants. We're going to work through that motion. It's case 2021-CV348234. Mr. Rucker, you represent Ms. Pullen. I think you already know this because you had agreed to, or a colleague of yours, delaying this case a bit. It is intertwined with a case I've already heard, and it's why this case was assigned to me, Vanessa Simmons versus the same two defendants. So we've got two different passengers of the same bus. Mr. Simmons's case has been closed out. I granted summary judgment to the defendants in that case. And I think there was an issue with the way in which Mr. Simmons managed his appeal, but regardless, it's an order that stands. It's not the law of this case because we've got a different passenger, but it gives me an information source that I wouldn't normally have in a case. I'm just very familiar with the video footage from the bus, the black pickup truck that pulls in front of the bus, et cetera. And I share all that just so you understand, Mr. Rucker, why I'm actually going to have you start, because I understand the basis for the motion for summary judgment. It's an identical basis to the one that I granted earlier, but I want to reiterate, it's not going to necessarily be a carbon copy because, one, you may have raised different arguments from counsel for Mr. Simmons, and two, it's a different passenger. So that person, while similarly situated, is not a clone. So I want to give you a chance to do that. You got tied up. It sounds like there was traffic, something. We were supposed to start at 9:30. I have another hearing that starts at 10:30. I'll start it a little late, but you're going to have a slightly more compressed window than you might have had. I don't want you to talk fast, although no one's taking this down. So as long as I can follow you, that's fine. But I would like you to start, Mr. Rucker, letting me know why you think summary judgment's not appropriate in light of what I've found in the past the video shows. It's the same video, so I'm not going to make different findings about it. You did raise some questions about, well, how long could the driver have seen the truck coming alongside the bus, et cetera, and concerns about whether the driver was complying with the Smith system of defensive driving, which I've learned more about since I have had other MARTA cases. But I want to open it up to you, give you a chance. You're welcome to stay seated. You can go to the podium. Doesn't matter as long as you're near a microphone because this is being live streamed as well, just in case someone wants to hear this or needs to hear this. But I don't mind if you stay right there or if you go to the podium. When you're done, I will give Mr. Deering a chance to respond and we'll go from there.
Thank you, Your Honor.
You bet.
Good morning, Your Honor.
Good morning.
My name is Ryan Rucker, and I represent the plaintiff in this case, Ms. Jasmine Pullen. And defendant's motion for summary judgment should not be granted because a genuine issue of material fact exists as to whether MARTA bus driver Sharon Vachon was negligent when she attempted to enter a lane of travel from the shoulder of a roadway after observing a vehicle traveling in the lane that she was attempting to enter and incorrectly assuming that the vehicle was going to continue straight and not attempt to turn onto the street that Ms. Vachon was blocking. Now, Your Honor, I'd like to begin by stating that MARTA, as a common carrier of passengers, has a duty to exercise extraordinary care in protecting and ensuring the safety of its passengers. A carrier of passengers must exercise extraordinary diligence to protect the persons of its passengers and is presumed to not have exercised such diligence when such a passenger is injured. Also, Your Honor, the courts have found that generally it's a question of fact as to whether a common carrier in which a passenger was injured has failed to exercise ordinary care or extraordinary care.
Let me ask you a question. You mentioned in your brief as well as just now that proof of negligence, or at least there's a question about it, is the driver's incorrect assumption that the truck would stay in its lane of travel. My recollection is that the truck did not signal. There's no evidence. Well, let me take one step further back. My understanding is that Ms. Pullen can add nothing to the discussion because she was asleep or dozing, her eyes were closed. She's on the bus and the next thing she knows, she's busted her nose or whatever her injuries were. Is that a fair statement?
It is, Your Honor. She did state during her deposition that she spoke with other passengers after the collision. They advised that there was a black truck coming and the driver attempted to improperly merge into the lane of traffic.
Okay, but in terms of Ms. Pullen saying, here's what I saw or I heard, it would be after the fact, maybe hearsay. I'm not saying we can't talk about that today, but given that, what we'd be relying on would either be witnesses you found who were on the bus who can talk about it, or this is if the case goes to trial, we'd be relying on the video, of which there's much because there's so many cameras on a bus, I learned. But my recollection is that the video footage shows that the truck was not signaling. So my question, what was the incorrect assumption that the driver made? If there's no signal, it's a correct assumption, rules of the road, that the truck in that lane of traffic is staying in that lane of traffic. So tell me what your allegation is. Here's some negligence. Driver incorrectly assumed the truck would stay straight. And if the law is, yeah, you got to be assuming people are going in your lane, then she could never move the bus as long as there are vehicles coming in her direction of traffic, signal or no signal. And that's not the law.
Well, Your Honor, the difference here is a coming carrier has to practice extraordinary care. And it's neither right for her to assume incorrectly or to assume, period, what another driver should do. In fact, she stated during her training that she's taught to expect the unexpected and she's taught to never assume anything. So whether she assumes it's going to go straight or she assumes it's going to turn, she should not assume anything. She should keep all options open. And Your Honor, further, the difference in this case and the last one, Ms. Simmons, that attorney testified or believed that Ms. Vachon was blocking the entrance of a parking lot. Your Honor, that was not a parking lot. And I asked Ms. Vachon during her deposition, were you not trained that the MARTA bus is not to impede an intersecting street? And Your Honor, that was an intersecting street. And she did not know that. She states, I've been driving this same route for years, and I know that is a driveway. She testified clearly that she did not believe it was a street. Had she known it was a street, I don't believe she would have been right to impede a street, knowing that there's a vehicle coming in the lane, approaching to the left, and keeping all of her options open as she was trained and not assuming anything. Then she should have said, well, hey, this is an intersecting street. There's a possibility, practicing extraordinary care, that this vehicle will turn right here, not assuming that he's going to go straight, not assuming he's going to turn, not assuming anything, but just keeping all eyes open and expecting the unexpected.
Okay.
So, and Your Honor, also, I believe that Ms. Vachon was negligent for not observing the black truck before it entered her lane of travel. Using the Smith system, she was taught that she's to slowly merge back onto the roadway while continuously checking her surroundings for the vehicles. She also admitted that MARTA trained her to observe her mirrors every few seconds when merging into traffic. However, she testified that she did not see the truck until it turned in front of her and cut her off. The video evidence shows that the truck was visible in Ms. Vachon's mirror for a full 6 seconds, 1,000, 2, 1,000, 3, 1,000, 4, 1,000, 5, 1,000, 6, 1,000 before he turned in front of her. She was negligent by not checking her surroundings constantly as she was instructed by the Smith system and by not looking into her mirrors every few seconds as she was trained to do. Further, Your Honor, she testified that she should have observed the vehicle in her mirror before it turned in front of her. During her deposition, she stated that she should have saw that vehicle before it turned in front of her. And I believe that's negligence, in itself by her testifying that she should have saw it.
Did she testify, if it was asked, that she would have done anything differently if she saw the vehicle that wasn't signaling?
She didn't say that she would have done anything differently, Your Honor. That wasn't asked, but she did state that she should have seen the vehicle before it turned in front of her. Okay. And Your Honor, I believe that whether she drove in accordance with her training is a question of fact and is one solely for a jury's determination. She didn't look every few seconds. She did emerge back slowly, and she was also impeding a driveway, not a driveway, a street, an intersecting street, which I believe is reckless driving. And I believe a common person, a lay person could easily find that to be negligent, especially if you're practicing extraordinary care. Also, Your Honor, there was this additional issue of material fact, and that's which I just stated, whether she was negligent by driving in front of and blocking an intersecting street, thereby impeding the entrance onto that street. I don't believe that her training teaches her that she should block these streets. I asked her about that. She would not respond. All she would say is that was not a street. You know, she would not tell me whether or not her training taught her to do that, but she was adamant that she could do it because it was not a street, when in fact it is a street, which leads to a residential neighborhood and several office buildings. And Your Honor, as I stated, she did breach the high standard of care for coming carriers when she went against her training. She assumed that the truck was going to go straight. She shouldn't have assumed anything, that it was going to turn or go straight. She's taught to always expect the unexpected. Had she not assumed that the truck was going to go straight instead of turning and onto the street that she was blocking, then she would not have had to strike her brakes so forcefully, causing injury to so many patients on the bus.
Do you agree that the record shows that at a minimum, Ms. Vachon wasn't screeching out of the bus stop when she did start rolling, that this wasn't contributing to something that's not present in this case, as I understand the record, is any argument, a fact-based argument that she was going too fast, in the sense that she slammed on the accelerator and was trying to get out of the bus stop at 30 miles an hour, as opposed to just starting rolling. But because she was rolling, and a bus is big, it takes a second to stop. That truck pulls in front of her and she has to slam on the brakes. I didn't ask that well, but you understand what I'm asking?
I absolutely understand your question, Your Honor. And there are no allegations that she took off at an accelerated speed. The only allegation is that she should have been aware of the fact that she was blocking a street, not assumed anything as her trainer taught her, and been aware of expecting the unexpected, assuming that this car could turn, or being aware that this vehicle could turn onto the street.
Got it. So your theory would be really the prudent course, especially if you're exercising extraordinary care, would be, I'm just going to let this truck go past. And I'll wait till I don't see anyone, because I'm blocking an intersection. And I'm assuming for a minute that's what it shows, that she's blocking an intersection. I think she may have been a little further back, but that's a question of fact, perhaps, whether she was effectively blocking the intersection. That the standard of care that she's required to exercise would be, you know what, expect the unexpected. Maybe this guy's going to swerve in front of me. It's just safer to let that truck pass, and I'm not going to pull forward until it's clear behind me.
Absolutely, Your Honor. Now, had she not been crossing an intersecting street, had it just been the shoulder of the roadway, of course she can drive down and say, I'll just get over once this car passes.
Yeah.
But when you have an intersecting street, you can't block that street when there's cars coming this way. You don't know when they're going to turn. I mean, we see people, even lay people, everyone on the jury would understand that vehicles change lanes without putting on their blinkers every day.
What is your understanding of the law, case law or statutory law? It seems like, I don't have a diagram in front of me, that operator of black truck committed a traffic violation if he made a right-hand turn onto an intersecting street from a lane that was not the right-hand lane. So in other words, the turn he made was an illegal turn. And so Ms. Vachon was encountering an illegal situation. In other words, an unexpected, I don't expect folks to brake. I know you're supposed to expect the unexpected, but that this guy made an illegal maneuver. If he was interested in turning right at that intersection, he needed to get behind the bus and wait for the bus to move. Happens on Peachtree all the time. I want to turn onto this road. There's a bus stop probably too close to the intersection, but it's illegal for me to turn from the center lane onto the street to my right. I need to either wait for the bus to move or do something different.
Well, Your Honor, and under that scenario, the driver would have been at fault. But in this situation, the bus driver actually was not in the lane. She was actually on the shoulder of the road, and the driver was in the turning lane. He actually was in the first lane that we would turn out of properly. He was in the lane that every ordinary driver would, be in to make a right turn. The only thing that driver did, which was negligent on his behalf, is he didn't put his blinker on. But Ms. Vachon was actually not on the road. She was on the shoulder of the road, which is where you don't even go, if you have a flat tire. So he was in the right lane. He shouldn't have gotten behind Ms. Vachon. She should have waited to see if he was going to turn on that street, because he was in the turning lane.
So if the truck had gotten behind the bus to wait for the bus to move, he would have actually not been on the street.
Right. He would have been on the shoulder of the road where.
Okay. Which would have been odd. That's like he's parking.
Right.
Okay. Or dropping someone off.
Right.
Okay. All right. Anything else?
Nothing further on it.
Great. I'll give you a chance to respond if you hear something from Mr. Deering, like, wait a minute, Judge, you got to give me 2 seconds to say X, because Mr. Deering he's got you confused.
Thank you, Your Honor.
All right.
Thank you very much.
Thank you.
Your Honor, may I remain seated here?
You may,
Okay.
that is fine. I'm going to start with a few questions and then let you go where you want to go with this. Do you agree with Mr. Rucker's statement that there exists or becomes a presumption that the bus driver failed to exercise extraordinary care whenever there's an accident? In other words, under law, there's a burden shift. It's rebuttable, but if a MARTA bus hits something, MARTA starts sort of behind and needs to show, you know what, that's not MARTA's fault because here's how it was an exercise of extraordinary care.
I think, Your Honor, with regard to the allegations, I guess we start that way, but the defendant must come forward with evidence. And unfortunately for the plaintiff in this case, we have a video, and I think that that's the best evidence that we could ever have in any case. And I think that because of that evidence is so clear, I think the burden then shifts back to the plaintiff. So to some degree, Your Honor, because of the existence of that very video, the evidence the burden almost shifts immediately to the plaintiff, and they need to come forward with evidence that can overrun that particular evidence that's set forth.
But as a starting point, there was a collision. Well, there wasn't a collision. She didn't hit the truck.
Correct.
But there was an accident in that by slamming on the brakes, two people claim they were injured, one of which is Mr. Rucker's client. And that sudden slamming on the brakes, the presumption is, MARTA was at fault because of that duty of extraordinary care. You can rebut it. And by rebutting it, of course, the burden shifts back to the party that in a litigation typically bears the burden of proof, the plaintiff.
Sure, Your Honor. And I guess the way you set that up, I guess that's true. However, our position is that Ms. Vachon acted appropriately from the outset.
I understand the defense's theory, but if there's not even that presumption, it's just a different calculus I need to work through. And so I was asking you, just as a purely legal issue, if you agree that that's basically that extraordinary care burden that rests on common carriers means that if there is an incident, we'll call it, the onus starts out on the defendant, the person being sued, the common carrier saying, no, wait a minute, we weren't negligent here, as opposed to having to prove some negligence. Second question, because this did not come up in the Simmons case. Talk to me about, this was an intersection of two streets versus it was a driveway, and whether that matters. And in conjunction with that, so sort of two questions. Does the record show, regardless of whether it was a street or a driveway or a parking lot, that the bus was impeding access to that turn?
I don't think it makes a difference, Your Honor. First of all, I don't believe that it was a street, but I don't think it makes a difference. The record is very clear that Ms. Vachon was on the shoulder of the road.
And by shoulder, you mean
basically a bus lane, a lane so they could effectuate the transfer of passengers.
So when the bus was stopped, it was not obstructing the flow of traffic.
No.
The way that road, whatever road it was on, was designed is that the bus could pull over to the right and regular traffic can keep on going.
Correct. Your Honor, it was on Fulton Industrial. It was not impeding traffic. The black truck, the mysterious black truck, was not in that particular lane, so it was not blocked by the bus. There was not a situation where the black truck had to go around it because the bus was already in a bus lane. So to answer your question, Your Honor, it really doesn't make a difference whether or not the plaintiff is arguing that somehow there was a street there. I don't believe that there was a street. The evidence is clear that Ms. Vachon stopped the bus, let on passengers, looked in her mirrors, did whatever she thought was appropriate, and didn't even really accelerate, just started to move forward in the vehicle cut in front. And Your Honor, there is case law. I cited a case I was trying to find a case that I thought you might think was fairly interesting. And I found a case that obviously I cited in the brief, but it's Gillum versus MARTA. And it's a 1982 case. And it's a really good case. It's the site is 160 Georgia Appeals 393. And in that particular case, the plaintiff alleged that MARTA bus was stopped too suddenly, and that the folks that were on the bus the plaintiff was on the bus that was injured. The evidence in that case was that someone had darted in front of the bus. And the court went through just a basic discussion that in that situation, sort of accepting your Honor's calculus with regard to where the burden starts, that the defendant came forward, the MARTA folks came forward with evidence that this is what happened, that there was a pedestrian that ran in front of the bus, and that it was necessary to stop the bus and to avoid injuring the pedestrian. And that at that time, it was necessary for the plaintiff, the burden shifted. The plaintiff was to come forward with evidence that could overcome that presumption. Now, in this particular case, unfortunately, and I asked the plaintiff throughout her deposition, what happened? What happened? She was asleep. She was asleep. She could not offer any testimony, any evidence regarding what the bus driver could have done differently to avoid having to stop the car suddenly. Now, even if you were to accept Mr. Rucker's proposition that, well, you have to always be ready and anything can happen, that's his argument. There's nothing that the plaintiff can add to that. Furthermore, I thought, for example, in a case like this, that something that probably could have been done, I guess, would have been to have an expert to come in and say, well, based on what I've seen and based on where everything was positioned, that Ms. Vachon had other options that were less dangerous to the riders of the bus. But that didn't come up. We don't have that. So based on that, Your Honor, I think the plaintiff has fallen short in overcoming that burden, meeting the burden and overcoming the evidence that the defendant has presented. And I think summary judgment is absolutely appropriate in a case like this.
So you're describing a tale of shifting burdens because of that extraordinary care obligation that falls on common carriers. Basically, the allegation that something wrong happened is almost enough for defendant MARTA to have to come forward with something. The something here is just watch the video.
Yes.
And then we get, assuming that video shows that on the surface, at least, the driver was exercising care, then the burden shifts back to the plaintiff to say, no, here's why, or there's a question about whether that constituted extraordinary care.
Your Honor, I'll even go even further and say, if there had been no video, but there was testimony of the MARTA driver along with the MARTA investigation that, as you know, was carried on at the scene and after, and there were affidavits that were completed by MARTA employees. If there had been no video and we still had the other facts where the plaintiff was asleep and had nothing to offer, I think summary judgment would be appropriate even in that situation. But unlike most other cases we have a video. We can tell what happened and we can see what the driver did. So I think that summary judgment is appropriate.
And there's no deposition testimony in the record from other passengers on the bus. Is that correct? Depositions right now consist of bus driver and Ms. Pullen?
That is correct, Your Honor.
Okay.
And Your Honor, with regard to foreseeability, I mean, the entire question is about foreseeability. What could the MARTA driver reasonably have foreseen in a case like this? And obviously, from in another case that I thought might be helpful, Your Honor, is Stringer versus Stringer. It's involving a passenger that got on a bus and was shot. And there was some question about foreseeability. And the case site is 263 Georgia 641 It's a 1993 case. And they talk about just the burdens of a carrier and whether or not certain aspects of foreseeability are reasonable. In this particular case, guy gets on a bus and says, he gets on the bus and says, you know, somebody's after me, somebody's looking for me, you know, and he just seemed to be an odd guy. Guy gets on the bus and eventually shoots another passenger. The court determined that even in that case, that it was not necessarily foreseeable that the carrier would know that something was going to happen with regard to that. And that you are probably more than familiar with the case, Your Honor. No notice, basically. So in this case, obviously, we're talking about something that happened instantaneously, and there was no notice. There was nothing that the driver could have done to foresee that a black truck would cut in front of her and that she would have to react the way she did.
Okay.
Thank you.
Mr. Rucker, I noticed during Mr. Deering's presentation that the cavalry arrived for you and you got this big old Redwell. Are there things that you've just received that you want to share in rebuttal to what you heard from Mr. Deering?
There I am. I do have rebuttal.
Okay.
First, Your Honor, regarding the burden shifting, opposing counsel stated that he did as an extraordinary carrier with an extraordinary responsibility as a common carrier. He states that they did have the burden to show that they were different, that they weren't negligent. And he stated that they met that burden by the video. And Your Honor, the video definitely presents a genuine issue of material fact because we believe the video, as well as the jury could believe, shows that Ms. Vachon was negligent. It shows that she was impeding a street. And Your Honor, while he stated that she was not impeding the street, we produced photographic evidence from the video, which clearly shows that a portion of her vehicle is blocking the street. And we have screenshots of that. We show as she began approaching from here, Your Honor, she was back here pretty far back. She started back here. As she starts approaching, you can look out the window. And one picture, you'll see that there's grass, meaning that she's still in this area. As she looks, she's still parked here. But on the other video, when she has to slam on her brakes, when you look to the side, you see the pavement. This the same pavement that he's turning into. She's impeding that street. She's no longer blocking the grass. She's now
Well, you use the word impeding. As I drive down a street, I will be variously impeding other streets or driveways, whatever we call that intersection. As I drive by it, that doesn't make me any less careful because I'm in a lane of traffic. Right. If I'm not speeding, I'm driving consistent with conditions. As I drive down the street, I'm impede, to use your term. It's also, I am passing by. Right. So when you say impede, I was thinking initially she had stopped the bus in a manner that the bus was physically blocking the intersection, but that's not what it shows. Your first picture, the bus is it's further from the intersection. We could put a bunch of people, could park a couple cars in front of the bus before the intersection. At some point, she starts rolling. Mm-hmm. Once she's moving, why are you characterizing it as impeding as opposed to she's in a lawful lane of traffic and she's driving? She's in that lane. Technically, physically, she's impeding it, but why is this goofball trying to turn while the bus is right there?
That's a great question, Jan. The difference is, as you stated, every day when we're in the lane of travel, we are passing streets, and I wouldn't call that impeding. The only reason I use that word and what makes this scenario different is because she was on the shoulder of the road. Now, if you're driving in the lane of travel, of course you're going to pass by streets. I say impeding because she is on the shoulder of the road. The vehicles in the lane of travel that are supposed to turn on that street, she drives up the shoulder of the road and begins blocking that street. Now, she's not in the lane of travel that's supposed to drive and turn on this street. She's on the shoulder of the road where no vehicle should be impeding this street. No vehicle can, you and I, we can always drive in the lane of travel past the street, but we cannot get on the shoulder of the road and just drive down the shoulder and stop in front of them.
Right.
And that's exactly what Mr. Vachon did. And further, Your Honor, he gave examples of two other cases in which he stated are similar to this, and it shows that foreseeability is something that MARTA is not held to a high standard on. However, the two examples that he gave were ones in which the driver it was through no use of her own negligence. The first example was someone running in front of a bus. That's very different because we have no control over someone who runs out into the street. That person, I mean, you have to react. You're not causing that. Your negligence is not causing this scenario. That's someone running out into the street. In our scenario, Ms. LaShawn drove into on the shoulder of the road into an intersection and blocked that intersection, stopped when another car was turning. So it was her negligence that caused this issue. It's not someone else running in front of her. I mean, this bus did turn in front of her, but she shouldn't have been blocking that road, that street. And you're under the second scenario, someone getting on the bus and shooting someone. That's tremendously different from our scenario. Again, that's someone else's active negligence. That's someone else getting on the bus shooting someone, or just like someone running into the street. Here, Ms. LaShawn is a person that caused this. Had she not been blocking that street, had she said, you know, there's a street right there, I should probably stop right here and see, you know, make sure no cars are going to turn onto this street, this wouldn't have occurred. So it wasn't someone else's active negligence that caused it. And, you know, he did also state that my client was asleep at the time, but as he also stated, the very best evidence is the video. And I believe it definitely presents a question of fact for a jury to determine whether or not she should have been blocking that street. He did state that there's a question as to whether or not it is a street. He stated that it's not. But I actually pulled up Google Maps, and as you can see, it's at one of my exhibits. It's a street called Maze Lane. And I further have a higher image. You can see it's a very long street that goes down with residential houses on it. It has office buildings. These office buildings have numbers, you know, 331 Maze Lane. So this is a street. It's not a parking lot. It's not a driveway. It is an actual street.
Okay. And you may be right. I'll have to see what's in the record while I work through that. But what I think I heard Mr. Deering say is MARTA doesn't think it's a street, but even if it is ... he thinks they still win. So I don't know that I'll need to resolve the question of whether it was a street or not, but certainly if that becomes central, that seems to be a disputed issue of fact. And there you go. So I'll be mindful of that as I'm working through your good arguments and Mr. Deering's good arguments to see, wait a minute, is anything I'm doing hinging on, was it an entrance to a parking lot, like a boulevard access, versus was it actually a street? I don't know that that's material, but if it becomes material, it's clearly disputed.
And, you know, I believe that is very material because I believe that's why she was negligent. Had that street not been there, she could drive over the shoulder of that road all day until it was clear for her to merge into the oncoming traffic. But when there is an intersection street, when you're practicing extraordinary care and you're to expect the unexpected, you're not to assume anything, you should always be mindful that there's a vehicle that will turn on this street. I mean, my daughter just learned to drive, she's 16. I could teach her, you always have to be aware people turn without their blinkers, without their drivers, you know, all the time. So if you're practicing extraordinary care, you should certainly practice those same safety measures.
Okay. Well, you are in that rare space I am too, with the kid learning to drive, and like just assume everyone out there is dumb and dangerous as you're driving. So my son's like going 10 miles an hour everywhere. Like, hey, you got to go a little faster. It's like, yeah, but all these people, what are they going to do? I don't just keep rolling. So, all right. Well, I appreciate that. Mr. Deering, you actually have the burden as the movement. And so I know we've taken this slightly out of order, but it's been helpful to me. Any last minute things you want to add? I will certainly, one, you flag them in your brief, so I need to look at them more closely, but I will look at Gillum and Stringer. Gillum in particular, because I think there's some strong parallels there. I appreciate Mr. Rucker's observation that it's a little different when a guy gets on a bus and shoots someone, but conceptually that notion of foreseeability, I think, is importable from that case to the scenario that we've got here. So I will certainly consider that as well. Did you have anything else?
Nothing else, Your Honor. Thank
Okay.
you.
So gentlemen, here's how this is going to work. I will take this under advisement. I will look at the cases and the briefs again. And if it's real clear to me how this ought to sort out, it may be that Ms. Niles sends an email to both of you saying, Mr. Rucker, draft the motion, draft an order denying the motion. And so you'll have the pen initially. When you've done a proposed order, that goes to Mr. Deering so that he can offer some suggestions, not, hey, no, you need to grant the motion. If I said it's denied, but there may be a disagreement about facts or something like that. And I'll look at both. Ultimately, it will be my order that I'll sign off on. If it's real murky to me and we're going to need to get in the weeds with complicated research, then I'll keep it and I'll write it. But it's not uncommon for Ms. Niles to reach out to the two sides saying the judge has decided to grant, deny on these grounds. And you'll basically get an order sooner if you draft it. But again, you're drafting it. It's not going to look exactly like what you put together when I ultimately sign it, because I'll take ownership of it. All right. Any procedural questions, Mr. Deering?
None, Your Honor.
Mr. Rucker?
Nothing, Your Honor.
Okay. appreciate everyone's time. You guys be safe out there and expect the unexpected,
Okay, thank you.
especially with 16-year-old drivers.
Yes, Your Honor. And Your Honor, I'd like to apologize again for running late this morning.
No problem. My only advice is reach out when it's happening. Ms. Niles had to track you down. And so once you're stuck, have cavalry call someone saying, hey, Mr. Rucker is stuck. He's running late, because it took a minute to figure out what was going on. Always accommodate when crises arise, because things do happen. So just let us know. And then we're not left wondering, did he forget the date? Is Zoom not working for him, or what the deal is?
Absolutely, and I would never forget the date, but I surely will make the court aware next time.